Hail to all legal warriors. In this video, I'm going to cover the 3 biggest mistakes to avoid in a domestic violence case. If you're charged with a domestic violence crime, especially in Washington State, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like it, please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. If you are charged with a crime of domestic violence, if somebody is charged with a crime of domestic violence that you know, a loved one, someone in your family, there are 3 big mistakes that someone in that situation needs to avoid when we are dealing with the charged domestic violence offense. And the most common offense we're talking about is domestic violence assault in the 4th degree, a gross misdemeanor. It could be assault in the 3rd degree, assault in the 2nd degree. It could be any domestic violence charge, malicious mischief, harassment, but the mistakes to avoid are all the same. I think the first mistake we need to avoid is violating the no contact order. Almost always, if we get charged with a crime of domestic violence, at the arraignment or at the first appearance in front of the judge is going to issue a no contact order that says you can't have contact with the alleged victim. Now, if you were living with the alleged victim at the time, the alleged victim was your partner, your spouse, your boyfriend, your girlfriend, a parent, whoever, that means you're probably going to be thrown out of your house. And there's lots of ways we could violate the no contact order that we might not even think about. Some that I've seen happen over the years of my practice is, hey, it says I can't have contact with my spouse. It says I can't go to my house. But hey, I know my spouse isn't there. I'm just going to go to my house and get my belongings anyway. I'm going to go there. I'm going to get my computer and my clothes and stuff like that. That's not a problem. Well, that would be a problem. That would be a violation of the no contact order. And if it's found out, you could get charged with a new crime. Now, there is something called a civil standby on a no contact order that often gets checked that says, hey, if there's a civil standby on your order, you can follow the rules in that jurisdiction, but it basically means calling the police and saying, hey, I have a civil standby. Can you escort me to my home with the police to get my stuff, usually for 10 or 15 minutes? But some people can just violate the order because, hey, they think I can go home and get my stuff if the victim's not there. That's not the case unless you're following the civil standby rules. Additionally, people can get caught violating a no contact order, even if it's permissive, right? Sometimes the protected party, the alleged victim, says, yeah, come on home. I don't mind. Or, hey, let's go meet at Applebee's for dinner and talk about this. Well, just because the alleged victim says that it's okay to have contact with them, that's not okay, right? It's the judge's order saying you can't have contact with the alleged victim. So it's important that we do not violate the no contact order while the case is going on. And if you've watched this channel for a while, you might understand there's lots of ways we can get positive outcomes in domestic violence charges. But if you get a violation of the no contact order while the case is going on, that sort of really makes it harder on us to get a positive outcome because it gives the prosecutor so much leverage. Unlike a domestic violence assault 4th degree charge, usually there's no police witnesses that come after the fact. They're not sure what happened. On most order violations, the police are going to know what happened because they're going to catch somebody violating the order. Now the prosecutor has all the leverage. It's a whole different negotiation process, yet alone the fact that you're going back to jail, you're spending more money on attorneys and things like that. So it's important, the mistake number 1 to avoid is do not violate a no contact order while your case is going on. The second mistake you need to avoid is sort of, I'm going to call it apathy, laziness, inaction. It's basically doing nothing to try to help improve your position while the case is going forward. So if we were going to title it something, I would say not doing any type of affirmative classes is the biggest number 2 mistake to avoid. And what I mean by that is while this case is going on, usually we can improve a client's position if the client does some type of educational classes regarding domestic violence. The most common successful way of doing that nowadays in Washington State is something called DV-MRT classes. It's typically 6 months of classes, typically once a week with objective measures of success, not subjective like domestic violence typical treatment would be. And if you can do that during the period of a case, it can often improve your chances. What are some objections we get to that? Well, isn't that admitting guilt, Lance? Am I admitting guilt if I do classes? No, you're not. You're not admitting guilt. In fact, those classes cannot be used against you in court. They wouldn't even be able to be introduced into evidence by the prosecutor because that's simply not relevant and not allowed. And you'd want to talk to your attorney to see if it makes sense for you to do any type of classes, anger management, DVMRT, domestic violence victims panel, a full domestic violence evaluation, alcohol and drug evaluation, lots of things that might help your case. But your attorney hopefully will know what the culture of your court is, the culture of your prosecutor's office is, and what it is would be more likely to not only help you, but also help your case. It's a big mistake, though, typically if you do nothing, in my opinion, because we're wasting time where we can make it easier for the prosecutor to feel part of the solution to the case. If you do nothing, you really only give a sort of a binary black and white option for the prosecutor. Go for your throat or not, right? If you've done something, now the prosecutor can say, well, look, the clients helped themselves. I've sort of forced them to help themselves. Now maybe I can look at more varied options to resolve the case that can take it into account the defenses or your lack of any history that your defense attorney is raising with the prosecutor. I think the third mistake that I want to cover here, and it's a really important one, and it's more prevalent in domestic violence cases than other cases, is the client trying to rush the case. And why a client wants to rush a case more in a domestic violence case is because they're usually suffering under that no contact order, right? They might be out of their home. They're not talking to their loved ones. They may not be talking to their kids. So there's more sort of a level of needing to rush, a level of desperation, of timing. I need to be home. This is wrecking my life. And that may all be true. But as you may have heard me talk about before, usually a quicker resolution in the criminal case world is a worse resolution in the criminal case world. Usually time helps cases, and there's many reasons for that. It's mainly because the system is sort of set up that way. The system is backed up, right? The prosecutor early on in a case often doesn't really want to look at the case that early because they've got so many older cases where they're under the gun for about, hey, we're going to need to try to resolve this or go to trial. I only have so many trial dates available. There's a lot of psychology that plays a part of domestic violence prosecution, especially at the non-felony level. It's a little bit different at the felony level, but the non-felony level, there can be a lot of backup and overwhelm for the prosecutor. So what happens if you're the client and you're trying to rush things for your attorney gives in to you, they may try to negotiate a little too soon, and once you get a no out of a prosecutor, sometimes it's harder to get a yes later, okay? Also, regarding no contact orders, sometimes the client wants that no contact order gone so quickly that they're more likely to get a no from the judge because the things that the judge looks at about a request by the alleged victim to drop a no contact order, the primary thing they look at is time. How fresh is the supposed assault? The more close it is in time, the newer the case is, the more jeopardy the judge feels, and the less wise it would seem to drop an order because there's been less of a cooling off period. Also, the second thing the judge looks at in dropping a no contact order typically would be what has the defendant done to change their position since the no contact order was entered originally. I can't tell you how many times I've heard a judge say, what is different today than when I issued the order 2 weeks ago, counsel? Well, if the client's not done anything, we can say, well, it's been 2 weeks, right? But the client has done some classes, has done DVMRT, has done a DV victims panel, has done anger management. Well, judge, it's been 6 weeks. There's been no violations. They've also done these 3 classes. So I think this makes sense. There's a better risk for the court to go ahead and listen to what the victim wants to get this order dropped. At least that's what we're talking about in this hypothetical. If we rush things, we're more likely to get no's. No's kill momentum, and that can make it harder for the case to be resolved how you want. So 3 major mistakes to avoid. And you can see how they're sort of all related to actions that you can control as the person in the situation to help your attorney help you get a better result. So I hope you found that useful. So please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you've got a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years. We get on board. We'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.